How about if they do it overnight, depriving you of sleep, and they don't give you food and water or let you use the toilet? Now it's become coercive. How about you don't get to leave until you admit to the crime? How about you're just locked up until you sign a confession? The only corroborating witness to the complaining witness's testimony has a vendetta against the defendant. I wonder if there could be a motive. You said you'd give him the results, and then you gave him false results, which is not giving him the results now, is it? That kind of shenaniganery is why people distrust the police and the court system, and why lawyers like me tell them to mistrust police and the court system. Remember this stuff, people. The police are not your friends. I'm so sorry, but they're not. At least not when you're in this situation.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
All right, join me as we go on a journey of when the police can lie to you and when they can't. This is a hot topic for lawyers, especially criminal defense attorneys, because the police are allowed to lie to you. In many, many, many cases, in fact, the vast majority of the cases, the police can tell you a lie. And if you then admit to something, say something against your own interest, confess to the crime, okay, they got you. And the way this usually works is they'll say they saw you at the scene of the crime or something like that. Well, we saw you. Well, we got camera footage that shows you at the scene of the crime. But officer, I couldn't possibly have been there. I was at home with my wife and my kids. Oh, but we got camera footage and we got 5 eyewitnesses that say that you were the one with the knife stabbing the victim at the scene of the crime at the exact time with the thing. And they might maintain it. They don't have to like back off when you deny it. So play the game of hyperbole with me. Hyperbole is a tool. When does it become too much? When does it cross the line? If that little exchange that I just did in 30 seconds there off the top of my head just happened, okay, that's not like coercion by police or illegal or something like that. But how about if they do it for 11 hours? How about if they do it overnight, depriving you of sleep, and they don't give you food and water or let you use the toilet? Now it's become coercive. How about you don't get to leave until you admit to the crime? How about you're just locked up until you sign a confession? Now it's extremely coercive. Like, so yes, there's a line. We have to admit there's a line, and at some point it's too much. Well, this case is about where that line is, and they're not going to mince words. They're going to get right into it. This is in the Supreme Court of the state of Hawaii versus Keith. This is the state of Hawaii versus Keith T. Matsumoto. And this is, I think, the highest court. This is the Supreme Court. Remember, some states have the Supreme Court as the lowest court in the land, New York, but most of the time the Supreme Court is the highest court in the land. And this is Judge Pollack writing. The defendant in this case confessed to a crime after an interrogating officer informed him untruthfully that he did not pass a polygraph test. Our case law has established that deliberate falsehoods extrinsic to the facts of the alleged offense, which are of a type reasonably likely to procure an untrue statement or to influence an accused to make a confession regardless of guilt, will be regarded as coercive per se. Per se means automatically, more or less. So coercive automatically. No more further proof required. The trial court in this case determined that the defendant's confession was voluntarily made and admitted it into the evidence over the objection of defense counsel. The court also ruled that the defendant, during his trial testimony when discussing the circumstances of his confession, could not mention the word polygraph, the word test, or that the interrogating officer gave him inaccurate test results before his confession was elicited. So he wasn't even allowed to present evidence of his own innocence, relevant evidence of his own innocence. In this appeal, we consider whether a deliberate falsehood regarding polygraph results impermissibly taints a confession, We also address whether the court-imposed limitations on defendant's testimony violated his constitutional rights to present a defense and to confront witnesses. Lastly, we determine the propriety of the court's instruction to the jury that defined an element of the charge offense. Based on our review, we conclude that the circuit court erred in its rulings on these three issues and accordingly vacate the defendant's conviction and remand the case for further proceedings consistent with this opinion. So great, the defendant's conviction is vacated, but the defendant still has to go back to the lower court and go through with their trial again. Keith T. Matsumoto was arrested at a wrestling tournament at Farrington High School on the island of Oahu on June 9th, 2012, based on allegations that he committed an offense during the tournament, the kind of offense we can't talk about on YouTube. Matsumoto was subsequently indicted in the circuit court for the assault in the third degree and violation of the law. Matsumoto moved to suppress statements that he made during and after a polygraph examination conducted while he was in police custody on June 10, 2012, as well as any other item of evidence recovered by the Honolulu Police Department after that date. A hearing on the motion was held at which Matsumoto, Detective Alan Kuana, and Detective Kim McCumsey testified about the events surrounding a series of custodial interrogations, that means in custody, that means he's being held against his will, that took place following Matsumoto's arrest. Matsumoto testified that he was the state coordinator for wrestling for the Hawaii High School Athletic Association, and that his daughter was a wrestler and that he had gone to Farrington High School with his daughter to volunteer at a wrestling tournament. Matsumoto stated that at about 12:30 p.m., he was asked to step outside where police officers placed him under arrest. He was taken to the main station, he testified, where he was booked and held in custody until approximately 8:30 p.m., where he was removed from his cell and taken to an interview room. So already 8 hours in custody. He was taken to an interview room. He stated that Detective McCumsey, after going over a waiver of rights form with him, proceeded to interview him about the events of that morning, told him he would have to take a polygraph test, and then returned him to his cell. During her testimony, she testified that Matsumoto had agreed to take a polygraph test on his own volition when she asked if he was willing to submit to the test. So if you're unfamiliar with a polygraph test, because I know that they get sort of dramatized in the media, let me go over how a lie detector test actually works. And I'm sure that someone can provide more detail than this. So please take this with a grain of salt too, for real. A polygraph test is where they hook you up to a machine that measures various stats of your body, basically your heart rate, the galvanic voltage or whatever of your skin, basically the conductivity of your skin, which measures how sweaty it is, heart rate, breathing. They might do other things these days with modern polygraphs and modern technology and all that. And they're watching for changes in your statistics, your body's reactions to things as they ask certain questions. A polygraph is not automatic. It takes a skilled interpreter to interpret it. And because it's open to the interpretation of a person, they are generally not admissible in court. What's at issue here is whether an admission of guilt from a polygraph can then be used in court when they intentionally lied about the results of that polygraph. Because remember I said, it's not like you get to see like ding, 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 it's green or ding, 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 it's red. That does not happen on a real polygraph. You will never see that on a real polygraph. What you will see is needles move all over the place. And maybe you'll see a change in the way the needles are moving, maybe indicating an increase in heart rate, an increase in perspiration, an increase in nervous movement or something. And if the polygraph administrator, the person giving the polygraph, has asked baseline questions so they understand what your reaction is to a question that you're answering honestly or that has not surprised you, then they can see where the changes are. So, for example, I'll tell a true story. When I was being interrogated by the fake cop lawyer, the fake cop's lawyer had the right to cross-examine me at the arraignment. She asked me a question that like got a rise out of me. She asked me if I realized that there was other video camera footage of the incident. And like my brain went, oh, did I do anything wrong that I have to worry about? And like for a moment, I got like red in the face and got like sweaty. And I'm sure that would have been like spikes all over the place on my polygraph. And then I realized that she was just trying to fluster me and that I hadn't done anything wrong. But it did. For a moment there, my polygraph would have shown a reaction. However, I wasn't on a polygraph. I was just under oath. So I answer honestly and everything, and the rest is history. And he pled guilty to assault and impersonating a police officer. But so this polygraph that I'm describing here is a person sitting in a room interrogating you, first asking you baseline questions and looking at the results, and then comparing those results to the results when they ask questions that they expect you to lie or otherwise to have a reaction to. So, did you murder the person? Did you assault the person? Are going to be questions that we expect to see a difference or a change on the polygraph. And if that change rises to a level that the polygraph examiner thinks you're lying, then that will indicate to the polygraph examiner that you're lying. Let's continue. The next morning, Tecumseh escorted Matsumoto to a polygraph room. She introduced him to Detective Kawana and then left the room. Detective Kawana gave Matsumoto a polygraph waiver form that indicated Matsumoto would be provided with the results of the polygraph immediately following the conclusion of the examination. Detective Kawana, so they're setting it up. They're setting up their lie. Detective Kawana then put electrodes on Matsumoto and hooked him up to the polygraph machine. Detective Kawana asked a series of questions unrelated to the events to calibrate the polygraph. Among other things, Detective Kawana asked Matsumoto about his divorce, told Matsumoto to say he was holding a $5 bill when he was instead holding a $20 bill. So they'll ask you to lie, and if you've seen the dramatization of this, the asking you to lie will be like a material question that never happens on a real polygraph. Instead, you'll be asked to do something really obvious, like to say that something is orange when it's blue, or say this is a $5 bill when it's really a $20 bill, so that they can see how your internal structure, your body's nervous system and such react. Your body's physiology reacts when you lie. That's all normal so far. Maybe not the part about getting the polygraph results. They don't usually give you the polygraph results. So that if they're giving you the polygraph results, it's because they want you to have the polygraph results. Remember this stuff, people. The police are not your friends. I'm so sorry, but they're not. At least not when you're in this situation. Maybe when you're talking to your local cop out front. Sure, cops are your friends then all you want. I still think you shouldn't tell him anything that you can get in trouble for, and how would you know? So don't. But that's not what I'm talking about. I mean, when you're in the interrogation room, the cops are not your friends, and you need to remember that. There's a footnote here. Matsumoto testified that while being held at HPD main station, he was placed in a concrete cell without an adequate blanket to shield against the cold temperature, which aggravated an existing spinal injury for which he had previously had surgery. He further stated that he had eaten very little, had not slept much, and had become dehydrated because it was difficult to drink from the fountain in his cell, which caused his contact lenses to dry out and scratch his cornea. Matsumoto testified that he informed Detective Kawana of his physical state prior to taking the polygraph examination. Detectives Tecumseh and Kawana testified that Matsumoto appeared well rested and did not seem to be in any pain or discomfort. BS. How could you not be in discomfort from being held in a cold jail cell for 8 hours before your polygraph? Why do you think they held him in a jail cell without a blanket for 8 hours before his polygraph? Police are not your friends. Matsumoto testified that Detective Kawana then interviewed him regarding the events of the previous day. He stated that upon completion of the test, Detective Kawana removed the electrodes and told Matsumoto that he did not pass the polygraph test. Detective Kawana never used the term inconclusive, and he did not show Matsumoto the test results. According to Matsumoto, Detective Kawana continued to interrogate him and refused to accept his answers, stating that there had to be more on the basis that Matsumoto had failed the polygraph test. Matsumoto testified that Detective Kawana told him that he needed to make another statement, and then told Detective Macumsey upon her return that Matsumoto wished to speak with her. Following the conclusion of Matsumoto's testimony, Detective Macumsey testified. She stated that she initially asked Matsumoto if he would be willing to take a polygraph test because she offers every suspect who denies committing a crime the opportunity to take an examination. She testified that she believed Detective Kawana told her that the results of Matsumoto's polygraph test were inconclusive when she returned to the polygraph room after the test had concluded. Detective Macumsey stated that following the polygraph examination, she brought Matsumoto to an interview room, obtained a waiver of his Miranda rights, and interrogated him a second time. So now he's not only all that, 8 hours of discomfort plus the polygraph, and then being lied to about the results of the polygraph. Now he's going to be interrogated a second time because they didn't get what they wanted out of him the first time. Detective Kawana testified that there are 3 phases to a polygraph examination: the pre-test, the in-test, and the post-test, the last of which includes further interrogation if someone doesn't pass. What did I just say? Before giving Matsumoto constitutional warnings, Detective Kawana stated, he explained the 3 phases to Matsumoto and said that he would give him the results of the examination during the post-test phase. He did not tell Matsumoto that the post-test phase could include further interrogation. He testified that during the pre-test phase, he discussed with Matsumoto the difference between truth and lies, the test questions, and the allegations against him. The detective stated that during this phase, he interacted with Matsumoto as though he believed Matsumoto was innocent, and that it was his job to assist him in getting through the process. Detective Kawana testified that he also explained to Matsumoto during the pre-test phase how a polygraph works, informing him that it is a pass-fail test, either you pass or you don't. That's not how it works. It is not a pass-fail test. Either you can interpret it one way or interpret it another, and the reason why it's not admissible in court directly is because it's open to such differing interpretation. After conducting a practice test, Detective Kawana testified he moved on to the in-test phase. He testified that he asked Matsumoto a series of questions regarding the allegations against him and determined that the results of the polygraph test were inconclusive, meaning the score was right in the middle and did not fall within the range needed to pass or fail the examination. I guess it could assign some kind of score, but again, it is an interpretive score. It's like if you go to a choir competition and you have 3 or 5 judges who give you a 0 through 10 on different categories. That's what they're talking about, not a computer spits out a definitely right or definitely wrong answer. Detective Kawana testified that he nonetheless told Matsumoto that he did not pass the test. Okay, so this is technically true, right? He didn't fail the test, he didn't pass the test, it was inconclusive, so he can just say, okay, you didn't pass the test. He did not tell Matsumoto that the test was inconclusive, but he testified that he believed his statement was accurate. For the sake of the polygraph, an inconclusive result is not passed. What did I just say? These are exactly what these people are doing. Detective Kawana stated that he then moved to the post-test phase, in which he began to ask accusatory questions and told Matsumoto that he knew Matsumoto was not telling the truth. He explained that he intentionally shifted his attitude during this post-test phase as an interrogation tactic. Quote, when I go into the post-test phase, obviously, I have results from my polygraph. He didn't pass. I know there's some other things about the case, so then it becomes more accusatory. I become more confident in my accusations. It's no longer about whether or not you've done it. We know you did it. It's just a question of why you did it. So he's concluded from an interpretation of a polygraph after putting the guy in a cold cell for 8 hours and ignoring his medical needs. Detective Kawana testified that throughout the polygraph test, Matsumoto appeared to be in disbelief and was calm in a way that indicated Matsumoto could not believe he was in the position he was in. The state rested following the conclusion of Detective Kawana's testimony. Matsumoto argued that because the results of a polygraph test are inadmissible at trial under Hawaii case law, he would be unable to explain the basis and context of the statements he made during the in-test and post-test phases of the polygraph examination, and accordingly, these statements should be inadmissible. Matsumoto also argued that his statements during the post-test phase should be suppressed because they were the result of Detective Kawana intentionally leading him to falsely believe that he had failed the polygraph examination, which is an issue extrinsic to the facts of the case, and his statements were thus per se coerced and inadmissible under Hawaii law. Matsumoto also contended that Detective Kawana's cautionary advisory to him of what a reasonable person would be able to understand from the facts of the case, in addition to other circumstances asserted, amounted to a promise of leniency, resulted in his statements not having been knowingly, intelligently, or voluntarily given. In response, the state argued that, although results of a polygraph test are inadmissible, what have I been saying? The omission of the circumstances surrounding Matsumoto's statement should not render the statements inadmissible because they were supported by valid waivers of his constitutional rights. Matsumoto's statements, the state contended, were not obtained through coercion or trickery. And these people are confident. These state attorney generals, these district attorneys, these police officers think this is totally okay to do to people, and they do it to people on a regular, daily basis. This is not an outlier case. It is just an outlier that these facts led to a Supreme Court ruling. Many people who experience this kind of treatment can never do anything about it. That's why police need more oversight than conflict of interest-based internal investigations that clear them of all wrongdoing, and nobody gets to know the circumstances of the investigation. According to the state, Detective Kawana did not lie when he told Matsumoto that he did not pass the polygraph examination because the results were inconclusive and did not indicate that he had passed. The state also contended that Detective Kawana's advice that it would be better for Matsumoto to tell the truth was not deceptive or coercive and was calculated to enhance the trustworthiness of any subsequent statement by Matsumoto. The state thus argued that Matsumoto's waiver of his constitutional rights was knowing, intelligent, and voluntary. The circuit court orally denied the motion to suppress at the conclusion of the hearing and later issued findings of fact and conclusions of law. The court concluded that, while the results of the polygraph examination were inadmissible at trial, the post-polygraph interview was distinguishable from the polygraph test results, and the statements made during the post-polygraph interview were therefore admissible. The court further found that Detective Kawana's statement that Matsumoto did not pass the polygraph test was not a falsehood because it was technically true that Matsumoto did not obtain a passing result. And, even assuming the statement could be considered to be deceptive, the court continued, it would not be a falsehood extrinsic to the facts of the alleged offense that would be reasonably likely to procure an untrue statement. Matsumoto could have insisted that the test was wrong and that he had been telling the truth. The court thus ruled all of Matsumoto's statements were admissible. And the court did too. The lower court and the appeals court both thought it's totally okay to put somebody in a cold cell, ignore their medical needs, tell them that they failed a polygraph when they didn't, and then use all of these things against them in court to get a false conviction. All of those people think that's totally okay, and you wonder why I'm so passionate about access to justice. The court did not independently address Detective Kawana's advice to Matsumoto that it was important to tell the truth so that a reasonable person could follow his account, or Matsumoto's testimony that Detective Kawana's promise of leniency if he confessed, but it ruled that Matsumoto's statements were intelligently, knowingly, or voluntarily made without police coercion. So again, the court made a ruling on intelligently, knowing, and voluntarily made, but it did not make a ruling on these other things which would have been touched by whether things were intelligently knowing or voluntary. Great job, court. Really great job half-assing it there. Prior to trial, Matsumoto filed a motion in limine, or motion to limit evidence, regarding the statements he made following the polygraph examination. At that hearing, Matsumoto again argued that Detective Kawana's statement to him that he did not pass the polygraph test was a material misrepresentation. Matsumoto argued that the fact that he took the polygraph examination should be admissible, as should the fact that he was told that he did not pass. Otherwise, Matsumoto argued, the jury would not know the context in which the statements were made, including that his statements were motivated by his false belief that he had failed the polygraph examination. So then the court doubles down on it and won't even allow him to defend himself in front of the jury by saying what he was told at the conclusion of the polygraph examination. I'm at the edge of my seat here. The circuit court ruled that there was to be no mention of the word polygraph or the word test. The court further ruled that Detective Kawana would only be allowed to testify that he made a statement to Matsumoto that was not totally true. The parties were also not permitted to say to the jury that the statement was a material misrepresentation. Trial commenced on January 17th, 2014, and included the following testimony. The complaining witness testified that on the day of the tournament, Matsumoto assaulted her in ways that made her feel uncomfortable. The first time occurred when she was getting pre-match paperwork, and there's a description, you can read it for yourself. And she says that he bumped into her and his hand slid across and touched her. The complaining witness testified that there were many people in the area and she believed that it was an accident, but she says it happened a second time while he was coaching one of her friends. She testified that she remembered him walking up behind her, talking to her about wrestling stuff, massaging her shoulders, and then touching her stomach. She tried to leave. He slapped and grabbed her with both hands. After the second time happened, she went straight to her father. She testified that it was not a congratulatory touch for anything. A volunteer wrestling coach at the high school who was familiar with the complainant testified for the state. He said that he saw Matsumoto commit the act and that the witness reacted by getting up immediately, acting distraught, and leaving. According to the other coach, as part of mandatory reporting obligations, he insisted the police be called. So the actual underlying act may have happened, and the police are going to screw it the heck up by trying to obtain a false confession. What great police officers these are. Detective Kawana testified that his post-polygraph interrogation of Matsumoto lasted 3.5 hours. It was not recorded, but he took notes. During the first part of the interrogation, he testified that he attempted to develop rapport, and then he asked for facts about the case. Matsumoto stated that he did not commit the act in any way. Detective Kawana testified that he then switched to a direct confrontation technique in which he exuded confidence in the fact that the person he was interrogating committed the offense. He acknowledged that during the interrogation, he provided some information to Matsumoto that was not completely accurate, but explained that interrogators are permitted to use deception within guidelines set by case precedent. Again, the police are allowed to lie to you to obtain a confession. It's just that this one crossed the lines set by case precedent. So this is extremely important. You must understand the police are allowed to lie to you to obtain your confession or gain other evidence or information. Detective Kawana indicated that his goal was to get Matsumoto to admit that he had committed the act. Detective Kawana testified that although he knew there were inconsistencies in the various police reports, he told Matsumoto that he had solid evidence that based on what he had seen and what he knew, there would be no doubt that the allegations against him were true. Detective Kawana then showed Matsumoto a diagram of the gym, and he pointed out where Matsumoto was when the act occurred. Detective McCumsey testified that she observed and listened to Detective Kawana's post-polygraph interrogation through a viewing window. According to Detective McCumsey, by the end of the interrogation, Matsumoto admitted to the act, and she stated that following the interrogation with Matsumoto present, Detective Kawana told her what Matsumoto said in the interrogation as if she had not heard it before. She testified that Matsumoto agreed to submit to a second interrogation by her. The substance of those recordings was consistent with their testimony. During Detective McCumsey's testimony concerning her interrogation of Matsumoto, 2 video recordings of those interrogations were played for the jury. These videos had been edited to remove matters the court had ruled were inadmissible. Before the recording of the first interrogation was played, Matsumoto objected to giving the jury redacted transcripts of these videos. The deleted text was replaced by large black lines, varying in size from several lines, with some lines covering nearly a full page. Matsumoto argued that the large number of redactions were prejudicial because the jury would speculate as to the substance of the redacted words, and he requested that the jurors just watch the videos and not be provided with the transcripts. The court overruled Matsumoto's objection, allowed the jury to use the redacted transcripts, and instructed the jurors not to speculate regarding the redacted content. Are you kidding me? The guy gets held in a cold cell for 8 hours, et cetera, et cetera, et cetera. And now he can't even let the jury see what actually happened to him. So the jury gets to see a modified version of what happened to him and then rule on whether this person is this kind of offender. That's how stacked against these people the system is. If this guy is an actual offender, the system is doing everything it can to make it harder on the prosecution side. The system instead should be making it easy on the prosecution side. Gather the evidence, make a rock-solid case. Instead of making a rock-solid case, they're coercing confessions with lies? Are we kidding? After keeping a person outside of their medical needs, no blanket, in a cold cell with no water? Really? Why don't we just treat the guy like a human being till he gets convicted, then throw him in jail because you got a good conviction? That's good police work. This is not good police work.
This is extremely disturbing.
Yeah, could you imagine if you are arrested, this is what you get to face? So imagine you got arrested for something you didn't do. You get to suffer just like they want a criminal to suffer pre-conviction, and they want you to really be weakened for that interrogation so that you'll do whatever they say. Are you kidding me? In the United States in 2017, are you kidding me?
I tell you, man, if this happened to me this way, I wouldn't be able to handle it.
Yeah, this would break people. This would break me. I am not a person of great fortitude. I actually feel a connection here because I can't stand the cold. Like, I have some kind of medical weakness or something. I used to do well in the cold. I no longer do well in the cold. I mean, I go into like severe shivers that I can only compare to a seizure. It's involuntary. I basically fall over shivering in a kind of seizure. If you put me in a cold cell for 8.5 hours or 8 hours without a blanket, I'm going to be literally dying in that cell. And that's what they did to this guy. And then they want a confession from him. And they want us to all take the confession. The guy probably did the thing based on all the different reports. But how do we know? How can we know when the cops have had to do all this lying after the fact to what? Just for what? Because they're so practiced at it, because they don't have anything better to do, because they don't know any better. They're so used to lying about these things that they just don't catch themselves when they don't have to do it. Why don't you just build a rock solid case with good police work? These people are detectives. In the second interrogation, Detective Tecumseh testified, Matsumoto made statements about not remembering how any of this could have happened, but said that he must have done it because when she tried to lock Matsumoto in to get him to commit to something regarding the incident, he responded, "I'm not going to say I didn't, but if anything, I would characterize it as a good job slap." After Matsumoto later said that he might have given somebody a good job pat on the butt, Detective Tecumseh stated she asked if the reason that Matsumoto touched the witness in that way was because it was a moment of bad judgment, and he said it was a moment of weakness. Detective Tecumseh testified that Matsumoto also agreed that he grabbed the complaining witness because the opportunity was there. In the interrogation, according to Detective Tecumseh, Matsumoto demonstrated a slapping type motion, not a grabbing motion. Following the state's last witness, Matsumoto made a motion for judgment of acquittal. The court denied the motion and Matsumoto proceeded with the case. Darren Reyes, the head coach for Farrington High School Wrestling, was the site director and host for the tournament. During the tournament, Reyes coached the complaining witness on a wrestling move. He testified that the complaining witness never told him that she had been inappropriately assaulted by Matsumoto and that she appeared jolly and cheerful subsequent to the match when the alleged incident occurred. So there's a witness that maybe shows that the incident didn't occur the way that it was complained about by the police. Corey Taniguchi, a volunteer coach at the wrestling tournament, testified that he was standing near the complaining witness during the second alleged incident. He testified that he saw nothing unusual. Another person, a student from Waipahu High School, refereed the match. He testified that he did not see this alleged incident at any time. Matsumoto testified on his own behalf. He indicated that he was the technical director for the Hawaii Technology Department Venture, a federal program that develops technology industry in Hawaii. Matsumoto stated that he wrestled in high school and in college and had been coaching since 1979. He also testified to previous incidents with Ulam, who Matsumoto portrayed as a negative person. Matsumoto stated that he blocked Ulam's student from participating in a tournament for failing to have a doctor's note. According to Matsumoto, Ulam reacted poorly to this decision. So there's motive for the false accusation. The plot thickens. Additionally, Matsumoto testified that at a separate tournament, he was required to block a student from wrestling for failing to weigh in. He was forced to ask Ulam to leave the coach's table, Matsumoto related, due to Ulam's disruptive reaction to his decision. So the guy has a history of overreacting. The only corroborating witness to the complaining witness's testimony has a vendetta against the defendant. I wonder if there could be a motive. At the time of the tournament, Matsumoto said that he was a certified USA wrestling coach and was involved in running wrestling tournaments and managing the state wrestling weight monitoring program. Matsumoto testified that he arrived at the tournament around 10:30 a.m. He explained that one of his two daughters was a wrestler at the tournament. According to Matsumoto, the first time he saw the complaining witness was at the scoring table. She was standing next to one of Matsumoto's daughters and other female wrestlers. Matsumoto stated that he just said hi to the complaining witness and did not want to bother her because she was running the clock for a match. Matsumoto testified that during the first alleged incident, he was focused on coaching and did not interact with her, and did not have any physical contact with her. Regarding the second incident, Matsumoto admitted making contact with her, but stated that it was a good job pat on the butt and not a grab as alleged. So if he did something inappropriate, so far, he's admitted to a good job pat on the butt, which is inappropriate in high school sports, especially across genders. But I would say that's inappropriate, but I'm not sure that that rises to the level of charging someone with this kind of crime. Do you? Let us know your thoughts. So maybe that did happen. According to Matsumoto, Detective Kawana suggested that if he gave the police something, apologized, and quit coaching, the case might not proceed. Matsumoto also testified that Detective Kawana told him that if he did not tell the police what he did, he would spend another night in the cell block, but that if he admitted something, they could work something out. Based upon Detective Kawana telling him about the strength of the case and providing him with misleading or inaccurate information, Matsumoto testified he began to doubt his memory. He stated that he never told Detective Kawana that he grabbed the buttocks, but he acknowledged that it was possible that he may have touched the witness. Matsumoto testified that he found out later that Detective Kawana gave him information that was not completely accurate, and that there was no doubt that the information was not completely accurate. During the third interrogation, oh my goodness, there's now a third interrogation.
This is what happens. This is what happens to innocent people in police interrogation rooms. They wear them down to the point where they begin to doubt their own sanity and their own memory, and they start to make false confessions.
Yep. And it's outrage. It's absolutely outrageous. During the third interrogation, Matsumoto testified he told Detective McCumsey that he could not recall the touching and gave various examples of how it could have occurred. Then there were jury instructions and verdict, and that's all described. The jury found Matsumoto guilty as charged. So no other charge or no lesser charge. No, they found him guilty of the full charge. Matsumoto was sentenced to 5 years of probation, which included a jail term of 6 months as a condition. Matsumoto appealed from the judgment of conviction and probation sentence to the Intermediate Court of Appeals. The appeals court first addressed the voluntariness of his statements. It held that he did not pass the polygraph test was not a deliberate falsehood because, strictly speaking, he did not score well enough to pass, and he did not score well enough to fail. So the test was inconclusive, so therefore inconclusive is not a fail or a pass. So you can tell somebody then they didn't pass. Well, you didn't pass. Yeah, that kind of shenaniganery is why people distrust the police and the court system, and why lawyers like me tell them to mistrust police and the court system. The ICA also concluded that the challenge statements of Detective Kawana relating to the polygraph test results were intrinsic to the charge, not extrinsic, because they related to the strength of the evidence, and so that allows them to come in, and that they were not coercive per se. They analyzed the totality of the circumstances surrounding the post-polygraph statements and held that the post-polygraph statements were also voluntary. So 3 interrogations after being 8 hours in a cold cell without water and neglected, and that's not coercive, according to the appeals court. That's the stupidity of the appeals court. The ICA determined that it was far from clear that hearing he did not pass the polygraph exam caused Matsumoto to make his post-polygraph statements. In addition, the ICA pointed to the detective's descriptions of Matsumoto as not appearing to be physically impaired, and Matsumoto's level of education as supporting the determination of Matsumoto's post-polygraph statement as voluntary. Yes, because the first stages of every physical ailment are you start showing it. Are you kidding me? Yes. The first instance, the first indicators that I have a stomach ache are that you get to see my stomach pop out of my mouth and tell you all, I'm not feeling well. Are you kidding me? No, I feel not well, and then I tell you that I'm not well, and he says he did that, and you ignored him.
And yes, a gym teacher education is definitely enough to be able to be questioned without a lawyer 3 times in an aggressive manner, for sure.
Yeah, definitely. After being deprived of basic medical and hospitality needs. I'm not talking about give the guy a TV and a Nintendo Switch. I'm talking about give him a gosh darn blanket. The ICA then addressed the circuit court's exclusion of evidence that Matsumoto's post-polygraph statements were induced. The ICA concluded that Hawaii case law does not provide for an exception to the prohibition against polygraph results, and that Detective Kawana's assessment of the polygraph results and his statements were properly excluded. So in other words, they wanted the statements in because they would show the jury that he had been coerced. So then the court allows the result of the polygraph and then denies how it got there in the first place. So he's not even allowed to defend himself with the fact that a polygraph was done and a false statement made. Viewing the testimony of the complaining witness and Ulam in the strongest light for the prosecution, the ICA held that there was substantial evidence such that a reasonable juror could have found him guilty. The ICA thus affirmed the circuit court's judgment. Matsumoto timely appealed. This court accepted. They review brand new. The admission of a confession or an inculpatory statement, that is, whether the confession or inculpatory statement was voluntarily given, is a purely legal question defined by the trial court as assessing the manner in which a confession or inculpatory statement was extracted. What that means is that they don't have to give deference to the fact-finding of the lower court. This is a question of law, and we are going to determine this question brand new. The propriety of the jury instructions is a question of law reviewed de novo. The jury verdict must be upheld if there is substantial evidence to support the conclusion of the trier of fact. Discussion. Voluntariness of statements. The constitutional right against self-incrimination prevents the prosecution's use of a defendant's extrajudicial admissions of guilt where such admissions are the product of coercion. The reasons for barring coerced admissions include the inherent untrustworthiness of involuntary confessions, a desire that criminal proceedings be accusatorial rather than inquisitorial, and a desire that the police not become lawbreakers in the process of achieving society's valid law enforcement objectives. So in other words, police can't break the law to enforce the law. They are not above the law, as much as it may seem that they practically are much of the time. A police officer's use of subterfuge to induce a suspect to make an incriminating statement may rise to the level of coercion, rendering the statement involuntary, untrustworthy, and inadmissible. When measuring the legitimacy of the use of deception by the police in eliciting confessions or inculpatory statements from suspects and arrestees, Hawaii courts evaluate the use of falsehoods regarding information intrinsic to the case differently from the deception that is extrinsic to the facts of the alleged offense. When the police use deliberate falsehoods extrinsic to the facts of the alleged offense, which are of a type reasonably likely to procure an untrue statement or to influence an accused to make a confession regardless of guilt, they will be regarded as coercive per se, automatically. Examples of extrinsic falsehoods include assurances of divine salvation upon confession, God will save you. Promises of mental health treatment in exchange for a confession, we'll take you to treatment instead of taking you to jail. Assurances of treatment in a nice hospital in lieu of incarceration, same thing, in exchange for a confession. Promises of more favorable treatment in the event of confession, so not even just more favorable treatment, so treating him disfavorably, and then he's going to hope that he gets his blanket and his water. And misrepresentations of legal principles, such as misrepresenting the consequences of a habitual offender conviction, or holding out that a defendant's confession cannot be used against the defendant at trial. So it's okay if you confess because we're not going to do anything with it, is also illegal. When the police use deliberate falsehoods intrinsic to the facts of the alleged offense in question, they will be treated as one of the totality of circumstances surrounding the confession or statement to be considered in assessing its voluntariness. So the lower court, the ICA, got it wrong there too. If it is intrinsic, then it has to come in, not get thrown out. Intrinsic falsehoods include, for example, a statement that a murder victim is still alive, a claim that articles of clothing were found at a crime scene, or an assertion that cameras were recording the area of the crime. So the camera example where I said before, oh, we saw you on camera, even though we didn't, that's intrinsic, and that becomes part of the totality of the circumstances, and maybe shouldn't be excluded from a jury's fact-finding or determination of a conviction. Matsumoto argues that because Detective Kawana employed an extrinsic falsehood to induce him to make incriminating statements, the circuit court should have concluded that his post-polygraph interviews were the result of coercion. Matsumoto contends that Detective Kawana telling him he did not pass the polygraph was a falsehood that should have led the circuit court to preclude his statements at trial. The circuit court concluded, and the ICA agreed, that telling Matsumoto he did not pass the polygraph test was not a falsehood, and even if it were, the falsehood was intrinsic to the offense, and therefore his confession was admissible. But again, they then said that the circumstances of the polygraph test, which are supposed to be intrinsic and part of the totality of the circumstances, were not admissible. So they're speaking out of both sides of their mouth and getting the confession and then not allowing the jury to hear how they got the confession. That is super not legal. Detective Kawana told Matsumoto that a polygraph examination is a pass-fail test. This was an incorrect or misleading characterization of a polygraph test and arguably of law, that the results may also be inconclusive, not just pass-fail. Detective Kawana acknowledged that there was a third possible outcome by explaining that Matsumoto did not score well enough to pass nor well enough to fail. Matsumoto was right in the middle. Despite previously explaining to Matsumoto that he would receive the results of the polygraph test, Detective Kawana never disclosed to Matsumoto that his test results were inconclusive. It takes one paragraph to do it properly. You said you'd give him the results, and then you gave him false results, which is not giving him the results now, is it? Detective Kawana's statement that Matsumoto did not pass the polygraph test, taken in conjunction with the earlier misstatement that a polygraph test could only be passed or failed, necessarily implied that Matsumoto had failed the polygraph examination, which was objectively false. Detective Kawana then reinforced this false impression by confidently stating Matsumoto was not telling the truth. which Detective Kawana described as an interrogation tactic to inform Matsumoto that he had obtained objective proof from the polygraph test that Matsumoto was lying. Matsumoto would thus have logically concluded that Detective Kawana was communicating the results that he was promised and which represented the entirety of the information gleaned from the polygraph test. Detective Kawana never corrected this impression by fulfilling his pledge to disclose the actual results of the polygraph examination, that the test results were inconclusive. Taken in context, then, Detective Kawana's statements to Matsumoto amounted to an objective falsehood, and in light of Detective Kawana's testimony that he was allowed to use deception with strict guidelines, and he was acting within those guidelines when he made the inaccurate statements, they were deliberate falsehoods. Thus, Detective Kawana used deliberate deception when interrogating Matsumoto. As stated, a deliberate falsehood will be regarded as coercive per se if the falsehood is extrinsic to the facts of the alleged offense and is of the type reasonably likely to procure an untrue statement or influence an accused to make a confession regardless of guilt. A deception of this nature obviates the need for a totality of the circumstances analysis of the voluntariness of the statement by the court in order to determine admissibility. The deliberate falsehood in this case was Detective Kawana's statements regarding the results of Matsumoto's polygraph test. The falsehood was not a lie by the officer about any facts of the alleged offense. It was not, for example, a falsehood about the existence of bystanders to the crime, or of witnesses coming to the station to give a statement, or the discovery of a weapon used to commit the offense. Instead of a lie being about the facts of the offense, it was a lie about the test results of a scientific instrument that was avowed to accurately determine whether the subject of the test was telling the truth. During Matsumoto's test, the polygraph indicated that Matsumoto lied about having $20 in his hand, emphatically external to the fact. And apparently, if it indicates that he lied, then that's correct, and then it couldn't indicate that he was lying about the rest, then he passed the test in my interpretation. But lying about the results of a scientific test is unequivocally not a lie about the facts of the offense, and the falsehood in this case was thus extrinsic to the facts of the alleged offense, not intrinsic, which is what I think the lower court, the ICA, had said, and then included his statements that were made as a part of the test. Additionally, to be coercive per se, the deliberate falsehood must also be of a type that is reasonably likely to induce an untrue statement or influence a confession regardless of guilt. In addressing this factor, we consider the nature of the polygraph test itself and the effects of its results on the examinee. The polygraph is a scientific instrument that purports to accurately determine whether the subject of the test is telling the truth. The common form of a polygraph test measures a variety of physiological responses to a set of questions asked by the examiner, who then interprets these physiological correlates of anxiety and offers an opinion about whether the accused was deceptive in answering questions. In other words, highly interpretive. An examinee who has not lied does not expect to be given falsified polygraph test results from the police. It is thus not surprising that the presentation of falsified results may have serious and substantial effects on a suspect. Quote, experiments have shown that counterfeit test results can substantially alter subjects' beliefs, perceptions of other people, behaviors towards other people, emotional states, self-assessments, and memories for observed and experienced events. Falsified polygraph results may pressure a suspect into changing the suspect's pre-test narrative. This pressure is intensified when an officer expresses confidence that the suspect is lying and is aggressive in pushing the suspect to confess on the basis of the officer's pre-formed belief of the suspect's guilt. Falsified polygraph results are geared towards making the suspect believe in one's own guilt or believing that the officer will not stop the interrogation until the suspect confesses guilt. Yes, I remember once not being allowed to leave the dinner table until I ate my overcooked, mushy, stupid tasting carrots. And that was also coercive. That made me eat my carrots, and I will forever hate the person who made me do that. Once a suspect believes that a confession of guilt is inevitable, the individual is cognitively geared to accept, comply with, and even approve of the outcome. That is, false polygraph results may psychologically prime an innocent suspect to make a confession. The case of the Norfolk 4 is emblematic of how falsified polygraph results can coerce a suspect into making a confession. The Norfolk Four were young men, each without criminal records, each enlisted in the Navy, and each trained to endure highly stressful situations, so people who should be able to overcome a coerced confession. These men were subjected to intense interrogation in which they were repeatedly accused of lying and fed information about the case. During their interrogations, the men each took a polygraph test and were presented with falsified polygraph test results. Only then did the men confess, in graphic detail, to a brutal murder that they did not commit. Shortly after their confessions, DNA evidence conclusively showed that none of the men was the donor of the sample recovered from the victim. Nevertheless, their cases were still prosecuted. One of the men was convicted by a jury of the murder and the assault. Another was convicted of the assault, and 2 took plea agreements to avoid the death penalty. One of these men became so convinced of his guilt that after the false polygraph results, he would go on to testify against the other defendants and even wrote apology letters to the families of the victim. Subsequent to their trials, the sole perpetrator of the crimes, who was already in prison for assault, confessed to the crime, and a DNA match was obtained from him. It took over 20 years for the Norfolk Four to be granted clemency. Extensive scientific literature and numerous documented cases have demonstrated the coercive nature of falsified polygraph test results. They can change a suspect's beliefs, pressure a suspect to confess, and even cause a suspect to believe they committed a crime when they did not. We thus conclude that providing falsified polygraph test results to a suspect as part of a custodial interrogation is an extrinsic falsehood that poses an unacceptable risk of inducing an untrue statement or influencing an accused to make a confession regardless of guilt. Thus, inculpatory statements or incriminating statements elicited during a custodial interrogation within custody from a suspect who has previously been given falsified polygraph results in the interrogation process are coercive per se and are inadmissible at trial. Accordingly, based on the foregoing, the circuit court erred in determining that Detective Kawana's falsification of the polygraph test results was not a falsehood and in admitting evidence of Matsumoto's confession. And then they go on to evaluate whether the admission of the evidence was harmless, and I'm going to say it's not, and we're going to skip over that because there's another 20 pages to go. Accordingly, the ICA's September 26, 2017 judgment on appeal and the Circuit Court's June 27, 2014 judgment of guilty with conviction and probation sentences are vacated, and this case is remanded back to the Circuit Court for further proceedings consistent with this opinion. Here's where they probably will make some kind of a deal with him, since there was such a tremendous violation of his rights. Maybe they will cut a deal and he'll admit to some lesser offense that maybe allows him to continue living his life too, because with this kind of accusation, a coach or teacher probably isn't working as a coach or teacher again, even if they are later found to be innocent. Sorry. I don't think that's fair, but that seems to be the way the world works these days. And tell us what you think about that as well. Do you think it's fair what happened to this person? Or do you think that maybe he did cross the line in the slapping of the buttocks and that deserves all this? Or maybe both parties did something wrong. Maybe he shouldn't have done that and they shouldn't have done this. Let me know what you think about that coercive polygraph lying cop thing. That was disgusting to see those detectives behave that way, and it was disgusting to see the court rule in all the ways that prevented a defendant from actually defending themselves. We want these people to be convicted on the merits, not because of shenaniganery from the cops and the courts. Let us know what you think in the comments below, and try to keep it civil because, it's YouTube. That's our show for today. Love you all. I am Leonard French, your favorite copyright attorney, and this is your favorite legal news and education program, supported by the direct financial support of our supporters on patreon.com/ljfrench and sponsors.com/law, and our subscribers on twitch.tv/lawfulmasses here. Thank you very much to all of our supporters in the month of December. I'm going to read the supporters for the month of November now because this is being produced on December 1st while Patreon and Sponsus are processing the pledges. So once the pledges have been processed, then we will switch over and we will get a different crawl for the videos that drop probably starting Wednesday the 4th. This happens every month, so do expect this to happen. If you pledge in December, you'll have this happening at the beginning of January. Thank you to our $50 plus supporters for the month of November. Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre W, Blackleaf, Benjamin Hitov, and Steven. And let me take a moment to say that I have looked at how much money some of you have donated over the life of this channel, and I am humbled and thankful for your contributions. As well as the $5 plus supporters. Some of you have donated a tremendously large amount of money over the life of this channel. The $5 plus supporters and all of the other supporters are scrolling on the LED panel behind me and will be on the crawl in the videos that drop. I'm Leonard French, your favorite copyright attorney. Thank you for your support. I love you all. I'll see you in the videos that drop. Bye.